The topic of today's blog is personal injury settlements. And one of the best tools in the personal injury attorney's arsenal is mediation. Mediation needs a bit of description because those who are unfamiliar with the process would gain some insight. Mediations typically occur after there has been quite a bit of litigation, and they can occur, as I had one recently, a matter of a few weeks before trial. But I've also seen mediations before a case is even in suit, that is, before the formal legal process has begun. And the reasons parties usually go to mediation, both plaintiffs and defendants, is to see if settlement can be reached. Years ago, mediations started getting into vogue, I'd say about 25 years ago, and my attitude was they are not necessarily all that effective. They're only as good as the money the insurance company will bring to offer a settlement of the accident. But I have seen, I'd say in the 25 years since mediations have been fairly prevalent, a very effective result. That is, the cases do indeed settle. Some mediators will tell you that their settlement rates are over 80%, perhaps even 90%. And what happens is one of the two sides will usually bring up the idea of mediation, and the courts also want to know if the parties have engaged in mediation or other forms of alternative dispute resolution. One form is arbitration, and that will be the subject of another blog. But right now, I would like to stick with the topic of mediation. So the parties come to a mediation. I go with my clients, and the defense attorney goes with an insurance claims person, and sometimes two insurance claims people. The defendant is usually not present at the mediation, but the plaintiff, the person suing for personal injury, is indeed there. After all, they have to sign off on any settlement. There is a short presentation, but it can be very much prepared, and there can be demonstrative evidence, and that's made by the plaintiff's attorney first. So I would go first, and I would present my case as best I can in 15 or 20 minutes, and present it both in terms of liability, responsibility, negligence, and damages. Oftentimes, liability isn't really much in dispute. After all, that's why the insurance company wants to come to settle the case. The defendants, after my presentation, go forward, and the attorney for the defendants, the insurance company's attorney, makes his or her presentation. At that point, the mediator brings the parties into separate rooms and begins the process of what I had heard years ago referred to as shuttle diplomacy. The mediator goes back and forth, and the numbers are exchanged. The plaintiff sometimes goes down, and the insurance company or defense comes up. Eventually, the hope is that you would come to an agreement of an amount of money. And that is, I am happy to say, increasingly what I see occurring as a result of mediations. That is, that they do indeed bring about settlements of personal injury actions. Thank you.